dedicated to my son, William Saul, July 29th, 1971, October 16th, 2012. Supreme Court of the State of New York, County of Erie, Honorable John David Sampson, Judge. William G. Iannaccone, Plaintiff, Pro Se, against Erie County Medical Center, Defendants. Affidavit of William G. Iannaccone in support of order to show cause for civil contempt and production of medical records and certifications. Index number 809651-2021. William G. Iannaccone, being duly sworn, deposes and says, Introduction and background. I am the plaintiff, pro se, in the above captioned action. I submit this affidavit in support of my order to show cause, seeking to hold respondents Erie County and Erie County Medical Center in civil contempt for its willful failure to comply with the New York State Supreme Court order dated December 21st, 1984, which directed ECMC to produce my complete and accurate medical records. I appear before this court pro se. I am a survivor of childhood abuse, and I bring this action pursuant to the Child Victims Act, CPLR Section 214G. I respectfully ask this court to enforce its prior order that ECMC and its legal counsel, Erie County Attorney, defied for decades, now causing plaintiff ongoing prejudice in preparing and presenting my CVA case. I make this affidavit based on my personal knowledge, my review of the records in my possession, and my good faith belief as to matters alleged on information and belief, which I believe to be true based on the facts and circumstances described herein. The 1984 order and ECMC's obligation to produce records. On December 21st, 1984, the New York State Supreme Court order of Honorable Henry G. Yassel, filed in index number H50268, ordered ECMC to provide as quoted. Quote, ordered that within 20 days of service of copy of this order upon the County of Erie, the County of Erie and its facility, Erie County Medical Center, formerly known as E.J. Meyer Memorial Hospital, deliver to petitioner's counsel herein complete original records concerning all care and treatment rendered to William G. Iannaccone at such facility, including records of all medications, referrals, directions, orders, consultations, payments, and reimbursements. A true and accurate copy of the 1984 order is attached hereto as Exhibit A and incorporated by reference. The 1984 order constitutes a lawful, unequivocal mandate of this court requiring ECMC to produce the records described therein. The order has never been vacated, modified, or stayed. Despite the clear command of the 1984 order, and despite the additional obligations imposed by Public Health Law Section 18, which requires health care facilities to make patient records available to qualified persons upon written request, ECMC has failed and refused to produce numerous categories of records that are plainly within its custody, possession, or control, or that were within its custody, possession, or control. I have made repeated good faith efforts to obtain these records from ECMC. Despite those efforts, the 4 categories of records described below remain missing and have not been produced. The 4 categories of missing records, based on my personal knowledge of the care I received at ECMC on the relevant facts and on information and belief based on the facts and circumstances of that care and the obligations imposed by law, I assert that ECMC possesses or possessed and has failed and refused to produce at least the following four categories of records. Category 1, outpatient therapy records, September through December 1968, Reverend Hardy. Soon after plaintiff's inpatient discharge from ECMC on August 24th and continuing through December 1968, plaintiff participated in outpatient mental health therapy sessions at ECMC with a, quote, pastoral counselor, unquote, known to me as Reverend Lawrence B. Hardy. I attended these sessions personally. I know from my own experience and the facts supporting this experience that I received this outpatient therapy. Plaintiff has a clear and vivid memory of these outpatient sessions with Reverend Hardy. They took place on a weekly basis and lasted 4 months, from December to December 1968. These sessions took place in Reverend Hardy's room. Reverend Hardy described his room as being in an, quote, unused wing of the hospital, unquote. Reverend Hardy's room was small and consisted of a cot, 3 chairs, dresser, and phone, appearing to be sleeping quarters. The entrance to Reverend Hardy's room was a metal door on a cement platform above a few cement steps with metal railings. My mother would drive plaintiff to and from these weekly sessions. Reverend Hardy would stand on the cement platform in front of the metal door to greet us upon arrival and departure. Upon entering, there were narrow windowless hallways leading to Reverend Hardy's room. The metal door entrance was located at the right side rear of E.J. Meyer Memorial Building and adjacent to the right side parking lot viewed from looking at the front of the building. Reverend Hardy was attending Divinity College in Rochester, New York at that time, and his room was most likely provided to him while he was commuting. Plaintiff's ECMC medical and inpatient records from August 5th to August 24th, released pursuant to the 1984 order, contain references to plaintiff's inpatient admittance being followed by outpatient treatment with Reverend Hardy as follows. Plaintiff's discharge summary of October 4th, 1968 by Zebulon Taintor, MD, Assistant Chief Psychiatrist, states as quoted therefrom, quote, he developed an intense relationship for the pastoral counselor. He was discharged on August 24th, 1968 to be followed by Reverend Hardy, unquote. Dictated by Virginia Rubenstein, MD. Attached here, too, is an accurate copy of plaintiff's discharge summary dated October 4th, 1968 as Exhibit B. Plaintiff's progress notes dated August 27, 1968, signed off by Dr. Rubenstein, and Dr. Lynch states as quoted in part, quote, patient has taken into intensive therapeutic relationship with chaplain shortly after admission and has stabilized, and at time is ready for discharge. He will be followed by Reverend Hardy, unquote. Attached hereto is a true and accurate copy of plaintiff's progress note dated October 22nd, 1968, attached hereto as Exhibit C. Plaintiff attempted to obtain his ECMC the September through December 1968 outpatient records with Reverend Hardy that took place at ECMC, at which time my sexual abuse by Reverend Hardy occurred at issue and necessary in plaintiff's CVA case. Plaintiff's January 25, 1988 letter to Mr. Charles L. Sawyer, Assistant Erie County Attorney, ECMC's former legal counselor, and respondent to the 1984 order, copy of January 25th, 1988 letter hereto attached as Exhibit D, states in part as quoted, quote, this is to notify you that your claim that Erie County Medical Center has fully complied to Justice Gossel's order as indicated in your enclosed letter of July 14, 1987, has been proven to be incorrect. Enclosed are two records referring to outpatient activity that were first provided to me in the enclosed envelope dated December 16, 1987. These records, 354 forms, were provided by the outpatient department, room 15, unquote. Attached hereto as Exhibit D are two copies of the 354 forms, front and back, as described above, showing years of outpatient activity for 1969, 1970, 1976, 1977, and 1978. However, not including 1968 at issue and necessary in plaintiff's CVA case. And including, as Exhibit D, is a true copy of the envelope postmarked December 16, 1987, from the outpatient department, pod 15, described above. Attached hereto as Exhibit E is a copy of the original July 14, 1987 letter by Mr. Sawyer, Esquire, as described above, where it erroneously states, as quoted, quote, "Please be advised that the County of Erie and the Erie County Medical Center have fully complied with the above referenced order by the Honorable Henry G. Gossel," unquote. In response to plaintiff's January 25, 1988 letter to Mr. Sawyer, Esquire, described above, Exhibit D, by letter of February 16, 1988, Mr. Sawyer provided plaintiff with his letter stated in part as quoted below. Quote, "This will acknowledge receipt of your letter dated January 25, 1988 regarding the above referenced matter. Pursuant to your request, I have instructed the appropriate personnel at Erie County Medical Center to ascertain whether there are any additional outpatient records pertaining to your care and treatment which have not been produced pursuant to Justice Gossel's order," unquote. Attached hereto as Exhibit F is a copy of the original February 16, 1988 letter by Mr. Sawyer, Esquire, as described above. Accordingly, Mr. Sawyer, Esquire, by his letter dated March 22, 1988, provided copies of plaintiff's ECMC outpatient records not produced at the initial release of plaintiff's medical records pursuant to the court order of December 21, 1984. Mr. Sawyer, Esquire, states in his March 22, 1988 letter, addressed to Mr. Richard Baumgarten, Esquire, plaintiff's former attorney, as quoted in part, quote, "Pursuant to the enclosed order of Justice Gossel, granted December 21, 1984, and at the direction of your client, we are enclosing herein copies of records of outpatient treatment rendered to Mr. William Iannaccone at the Edward J. Meyer Memorial Hospital," unquote. Attached hereto as Exhibit G is a copy of Mr. Sawyer's original letter of March 22, 1988. Also included herein as Exhibit G are copies of outpatient records provided by Mr. Sawyer with his March 22, 1988 letter, as described below. 1. Form 154, stating, quote, "Date August 28, 1969. Patient seen as a day patient on K1, Monday through Friday since August 14, 1969. Patient is doing well, and as of August 29, 1969, he will be seen at Teenage Group on Monday and Thursday night from 6 to 7 p.m. Signed, L.B. Hardy, Chaplain," unquote. 2. Form 61, Dr. Tan. Patient's name, Iannaccone William, Psychiatric Outpatient Department, dated July 13, 1976. Children, Sal, age 5, Colorado. Education or training, 12th grade. Past employment, Bethlehem Steel, unquote. Number 3, Form 134. Name, William Iannaccone, July 13, 1976. Patient is a 23-year-old white bearded male who appeared to be depressed. He was preoccupied with his, quote, uncreative and creative side, unquote. Patient does not appear to be motivated for treatment because he said he doesn't really feel he needs a psychiatrist, but would give me a call if he feels he needs one. Signed, Edward Tan, MD, unquote. Not included with the outpatient records provided by Mr. Sawyer, Esquire, by his letter of March 22nd, 1988, to Mr. Baumgarten, Esquire, are plaintiff's medical records pertaining to my weekly outpatient sessions with Reverend Hardy from September through December 1968 that took place at ECMC when sexual abuse occurred at issue and necessary in plaintiff's CVA case. Furthermore, Ms. Suzanne Kuzemski, RRA ECMC Chief Medical Record Administrator, is also known by the facts to be in contempt of the court order, granted December 21st, 1984, specific to my outpatient medical records following my inpatient discharges on August 24th, 1968 and August 4th, 1969, as shown below. By letter dated March 3rd, 1987, from Ms. Kuzemski, RRA, plaintiff received a patient's request to review and or obtain copies of medical information form that plaintiff filled out, signed, and had witnessed on March 3rd, 1987. Plaintiff's request for medical records was specific to, as quoted therefrom, quote, copy of complete records and other related materials created by outpatient department and outpatient therapy following inpatient discharges on August 24th, 1968 and August 4th, 1969. By letter dated May 6, 1987 to Ms. Kuzemski, RRA, plaintiff stated as quoted, quote, this correspondence is to confirm that 47 business days have passed without a response from you to myself or Mr. Peter Jason, my attorney, in regard to the enclosed letter of March 3rd, 1987, and request form dated March 3rd, 1987, unquote. In response to plaintiff's May 6, 1987 letter, Ms. Kuzemski, by letter dated May 7th, 1987, stated in part, as quoted therefrom, quote, I am in receipt of your letter dated May 6, 1987. A letter was sent to you on March 6, 1987, stating that there are no records of any outpatient activity for the dates requested. Attached hereto is a copy of Ms. Kuzemski's original letter and copy of the medical record request form dated March 3rd, 1987. Copy of my letter dated May 6, 1987, and copy of original letter of May 7, 1987 by Ms. Kuzemski, RRA, as Exhibit H. Ms. Kuzemski's claim that there were no records of any outpatient activity for 1968 and 1969 by her letter of May 7, 1987, preceded the production of copies of plaintiff's outpatient records for 1969, however, still excluding 1968, as provided by Mr. Sawyer by his letter of March 22, 1988, Exhibit G. The above facts prove there were outpatient records not yet released prior to the time of Mr. Sawyer's letter of July 14, 1987, making a false claim to have fully complied with the above referenced order by Honorable Henry G. Gassel. See Exhibit E for a copy of the original July 14, 1987 letter. And Ms. Kuzemski, RRA Chief Medical Records Administrator, false claim by her letter of May 7, 1987, that there are no records of any outpatient activity for the dates requested, 1968 and 1969. See Exhibit H for a copy of the original May 7, 1987 letter. Erie County and the Erie County Medical Center's obvious defiance of the court order granted December 21st, 1984, by the failure to provide plaintiff's outpatient records for the year 1968 at issue and necessary for plaintiff's CVA case is hereby shown by the facts. Upon information and belief, ECMC maintains records of outpatient therapy sessions conducted at its facilities, including records of the 1968 sessions with Reverend Hardy, the period in question. Such records would include, but are not limited to, intake and registration records, session notes and summaries, progress notes, discharge or termination documentation, and any other records relating to this outpatient treatment. These records have not been produced pursuant to the 1984 order. Their absence from ECMC's production is, in my good faith belief and the facts, the result of ECMC's willful failure to search for and produce them, as opposed to their never having existed. Category 2, inpatient and outpatient billing, payment, and credit records, August through December 1968. During the period from August 5th to August 24th, 1968, as an inpatient and September through December 1968 as an outpatient, plaintiff received care at ECMC. I know this from my personal experience, and plaintiff's ECMC medical records partially released pursuant to the 1984 order. Hospitals are legally required to maintain complete billing, payment, and credit records for all patient services rendered. Upon information and belief, ECMC maintains such records for all care I received during the August 5th through December 1968 period. Billing and financial records are an important category of evidence in this case because they corroborate the nature, extent, and timing of care rendered. The failure to produce these records deprives plaintiff of critical corroborating evidence. Mr. John D. Miller, Esquire, plaintiff's former attorney, prior to his improper withdrawal from plaintiff's case on November 4th, 1985, without a motion to withdraw, during the proceedings to compel defendants, Erie County and Erie County Medical Center, to fully comply with the court order of December 21st, 1984, did provide to plaintiff his original letter of September 25th, 1985, bearing the original signature of Mr. John D. Miller, Esquire, that enclosed his, quote, motion in support of further directives requiring Erie County's compliance with the outstanding discovery order, unquote. Mr. John D. Miller's notice of motion to compel compliance with prior order for discovery, dated September 25th, 1985, is supported by his signed affidavit of September 25th, 1985, where at paragraph 3, at C, it states, as quoted, quote, representatives of Erie County Medical Center have informally claimed to have none of the billing, payment, and credit records for petitioners' multiple periods of care at that facility, yet have refused to provide sworn responses as to the accuracy, authenticity, and whereabouts of such records. It is incredible that such materials no longer exist, but if that is to be the claim of Erie County and Erie County Medical Center, petitioner is entitled to have such claim made by the responsible parties under oath in a clear fashion, unquote. Attached hereto as Exhibit I is a copy of Mr. John D. Miller, Esquire's original letter to plaintiff, dated September 25th, 1985, bearing the original signature of Mr. John D. Miller, Esquire, with a copy of the notice of motion to compel compliance with prior order for discovery, dated September 25th, 1985, and with copy of the affidavit bearing the signature of Mr. Miller, Esquire, sworn to on September 25th, 1985, as described above, with copy of the December 21st, 1984 order by Judge Gossel, with attached copy of plaintiff's discharge summary. Of serious concern, legal action by Mr. Arthur F. Musara, Esquire, plaintiff's mother's former attorney since 1953, who was also an attorney for Local 210. As described in plaintiff's affidavit in support of New York State Attorney General's investigation at paragraph 24, sworn to on February 3rd, 2025, filed with this court, New York State Supreme Court Index number 809651-2021, on February 3rd, 2025, that is annexed to the complaint of pedophilic procurement, transfer of minors for sexual abuse by Erie County Juvenile Probation Officer to ECMC Pastoral Counselor, dated February 25th, 2025, sent to the New York State Attorney General, filed with this court, New York State Supreme Court Index Number 809651-2021, on February 26, 2025. Plaintiff states in my affidavit, as quoted, quote, Musara was involved in the alleged illegal transfer of the deeds of property belonging to my mother on August 2nd, 1968, to allow Erie County Department of Social Services to pay for my admittance to Erie County Medical Center, E.J. Meyer Memorial, from August 5th, 1968 to August 24th, 1968 as inpatient and to December 1968 as outpatient, where I was psychologically tortured and sexually molested by Reverend Lawrence B. Hardy, pastoral counselor. On August 2nd, 1968, Esther Zixay Ni Pontrello, my elder maternal cousin, who was employed at the Department of Social Services as an eligibility auditor, at that time transferred the real estate properties owned by my mother into her name for a few days, then transferred the property back on August 5th, 1968. Arthur F. Musara Esquire is shown on the deeds as a participating party. Note, the August 2nd deed was filed August 5th, 1968. The August 5th deed was filed on October 8th, 1969. See deeds attached as Exhibit G. Evelyn Jimerson, plaintiff's elder cousin, corroborated plaintiff's claim described above and wrote in her affidavit in support of New York State Attorney General investigation at paragraph 26, sworn to on February 7th, 2025, filed with this court on February 12th, 2025, that is annexed to the complaint of pedophilic procurement / transfer of minors for sexual abuse by Erie County Juvenile Probation Officer to ECMC Pastoral Counselor, dated February 25th, 2025, sent to the New York State Attorney General and filed with this court on February 26, 2025. Ms. Jimerson stated in her affidavit as quoted, quote, I am also aware that Musara was involved in the alleged illegal transfer of the deeds of property belonging to my Aunt Mamie on August 2nd, 1968, to allow Erie County Department of Social Services to pay for William's admittance to ECMC, former E.J. Meyer Memorial Hospital, from August 5th, 1968 to August 24th, 1968 as an inpatient, and to December 1968 as outpatient, where William claims he was psychologically tortured and sexually molested by Reverend Lawrence B. Hardy, his pastoral counselor. I understand that on August 2nd, 1968, Esther Ziziske Ni Pontrello, my cousin, who was employed at the Department of Social Services as an eligibility auditor at that time, transferred the real estate property owned by my Aunt Mamie, to her name for a few days, then transferred the property back on August 5th, 1968. Arthur F. Musara Esquire is shown on the deeds as a participating party. Note the August 2nd deed was filed on August 5th, 1968, and the August 5th deed was filed on October 8th, 1969. See these deeds attached as Exhibit G. Attached here too as Exhibit J is a copy of the affidavit of mailing of complaint to New York State Attorney General, sworn to on February 26, 2025, with copy of complaint of pedophilic procurement / transfer of minors for sexual abuse by Erie County Juvenile Probation Officer to ECMC Pastoral Counselor, dated February 25th, 2025, sent by certified mail to the New York State Attorney General and shown received on March 3rd, 2025. By copy of PO receipt filed with this court on February 26, 2025, along with copy of annexed affidavit in support of New York State Attorney General investigation sworn to by plaintiff on February 3rd, 2025, filed with this court on February 3rd, 2025, and copy of the affidavit in support of New York State Attorney General investigation, sworn to by Evelyn Jimerson on February 7th, 2025, filed with this court on February 12th, 2025. These billing payments and credit records have not been produced. Their absence is not consistent with any legitimate record-keeping practice, and in my good faith belief in the facts, reflects ECMC's willful failure to locate and produce them as commanded by the 1984 order. Category 3, neurology consultant and injection. Bernard H. Smith, head neurologist, March 7th, 1968. On March 7th, 1968, as a minor, at age 15 years, 3 months, I underwent a neurology consultation by Dr. Bernard H. Smith, head neurologist at ECMC. Immediately following the consultation, plaintiff received an injection by Dr. Smith, the nature of which plaintiff was not informed of at that time. Plaintiff clearly recalls this consultation and injection from personal experience and from plaintiff's medical records and the facts surrounding this event. Plaintiff's mother, prior to her departure from this earth in 1978, provided plaintiff with a security file with these words of wisdom. Quote, "There are things that people made me do. I don't have the heart to tell you. I want to leave you these papers. No one is going to help you. You're going to have to figure it out for yourself. This way, I'll know you'll be all right." Unquote. Among the key medical records was a letter from the neurology office of Bernard H. Smith, MD, Edward J. Meyer Memorial Hospital, now ECMC, dated January 23rd, 1969, that stated, as quoted therefrom, quote, "Dear Mrs. Iannaccone, I phoned Blue Shield concerning the check they were supposed to have sent you in July 1968 to cover Dr. Smith's consultation with William on March 3rd, 1968, while he was a patient at Meyer Memorial Hospital, signed by D. Johnson, secretary to Bernard H. Smith, MD," unquote. Attached here, too, is a copy of the original letter from Dr. Smith's office, dated January 23rd, 1969. As Exhibit K, the above described letter from Dr. Smith's office of January 23rd, 1969, given to plaintiff in 1978, jogged plaintiff's memory to the unusual events that occurred approximately 11 years earlier. Plaintiff vividly remembers Dr. Smith entering my room in the children's wing at ECMC. Dr. Smith introduced himself and asked me to accompany him to his office down the hall. On the thick wooden door was a brass plate with Dr. Smith's name on it. I entered the darkened room. A small, conical, green-shaded lamp dimly lit up his desk, where he took a seat in the corner beside a row of shuttered windows. I sat on a long wooden table facing him to my right, my feet dangling. "Are you William Iannaccone?" he asked. "Yes," I said. Dr. Smith's pen began to move on the paper on his desk. "Is your father Peter Iannaccone, who was a patient at the Canandaigua Veterans Hospital?" he asked. "Yes," I said. Again, the movement of Dr. Smith's pen. "You can go back to your room now," he said. Suddenly, he again appeared in my room. A large syringe emerged from under his long white coat, held upright in his hand. "I have something for you," he said, as he approached me. The needle penetrated my upper left arm. Slowly, the clear blue liquid in the large, translucent plastic syringe drained into my body. "How is this large volume of liquid going to fit into my arm?" I worried to myself. "Almost finished," Dr. Smith said. After the injection, he left fast, looking both ways down the hallway before leaving. Not long afterwards, a young nurse with long brown hair wrapped up under her white nurse's cap entered my room. "Who is in here?" she asked. "Dr. Bernard Smith," I responded. It was then that an older gray-haired nurse re-entered my room. She had just given me a urine test after the injection. She turned on the water faucet and said, "Watch the water flow. It will help you go." She too was in a hurry. "Who was in here?" the younger nurse asked, craning toward the elder nurse. "The neuro resident," the elder nurse said. The younger nurse looked back over towards me questioningly. "Put down neuro resident," the elder nurse demanded, pointing her finger emphatically. The younger nurse's eyes opened wide at me as she placed her hand over her mouth. "Oh no, not you too," she blurted out as she turned and hastily left out the door of my room. In my ECMC medical records progress notes, it is stated as quoted therefrom, quote, "March 7th, 1968, did more complete neuro exam, has been seen by neuro resident, but no note found." Here too is a copy of the progress note of March 7th, 1968, as described above, as Exhibit L. The above scenario of plaintiff's interaction with Dr. Smith establishes that there was a written record made by Dr. Smith in plaintiff's presence at the time of plaintiff's consultation on March 7, 1968, and that Dr. Smith's line of questioning of plaintiff would be consistent with the protocol required for research on a minor. Remarkably, plaintiff discovered from the microfiche records kept by the Erie County Probation Department a copy of a letter dated March 6, 1968 to the medical director, Harold J. Levy, MD, FAPA, Family Court, New York State, Erie County, from the VA Hospital, Buffalo, New York, stating, quote, "A request to furnish you information on the above-named veteran has been received," unquote. The March 6, 1968 letter included a, as quoted, quote, "copy of clinic report dated February 21st, 1968, forwarded at the request of your office and the written request of the veteran." Parentheses, illegal since my father was declared an incompetent person in 1960. Those are my parentheses. Where it states, quote, "He is being maintained on the medical regime of 50 milligrams of Thorazine. Veteran carries the current diagnosis of schizophrenic reaction incompetent since 1944. He is currently rated 100% disabled. Signed, Arthur D. Caldwell, clinical social worker." What makes this March 6, 1968 letter remarkable is that on the top right corner, it's scribed what appears to be received. EC, two following letters indecipherable, March 7, 1968. These facts reveal a correlation between the VA letter marked received on March 7, 1968, and Bernard H. Smith, MD, head neurologist line of questioning in his office at ECMC during plaintiff's consultation, confirming plaintiff's identity and that my father was Peter Iannaccone, who was a patient at the Canandaigua Veterans Hospital just prior to Dr. Smith's injection administered to plaintiff. Additional facts reveal a further correlation between the VA letter marked received on March 7, 1968, and Bernard H. Smith, MD, line of questioning in his office and ECMC. Plaintiff's ECMC medical record of report of consultation dated March 7, 1968, signed by Dr. Tutton, neurologist, contains the combined information that is contained in plaintiff's New York State Family Court records and contained in the February 21st, 1968 clinic report of plaintiff's father that was provided by the Buffalo VA to the New York State Family Court marked received on March 7, 1968, as quoted therefrom. His, of course, William, personal and family history is rather significant. His father is a schizophrenic on heavy doses of Thorazine, home from Canandaigua for the past year. We'll see with Dr. Smith, unquote. See copy of Buffalo VA letter of March 6, 1968, with VA clinic report of February 21st, 1968, hereto attached as Exhibit M, and report of consultation dated March 7, 1968 by Dr. Tutton, attached hereto as Exhibit N. Most outrageous. Erie County and the Erie County Medical Center are shown by the facts to be in contempt of the court order granted by Honorable Henry G. Gassel on December 21st, 1984, for my complete medical records filed in New York State Supreme Court Index H50268, since ECMC fails to provide or account for my medical record of consultation and injection by Bernard H. Smith, head neurologist, on March 7th, 1968 at ECMC, as substantiated by Mr. John D. Miller, Esquire, prior to his improper withdrawal from my case on November 4th, 1985, as described below. Mr. John D. Miller, Esquire, affidavit sworn to on September 25th, 1985, in support of his notice of motion to compel compliance with prior order for discovery dated September 25th, 1985, Mr. Miller, Esquire, states, as quoted from paragraph 3, quote, despite multiple conferences by deponent with the alleged custodians of such records and repeated visits by deponent to Erie County's facility in search of the mandated materials, Erie County and Erie County Medical Center have yet to provide complete materials required by such order. Specifically, A, the Erie County Medical Center records custodian refuses to certify that 1. They maintain records of all care provided petitioner at such facility, and 2. Petitioner has been provided accurate copies of records of all care provided petitioner at such facility. B. Especially illustrative is the absence of any records of the consultation of a Dr. Smith who provided care for petitioner at Erie County Medical Center in March 1968 and whose participation is referred to in the discharge summary of Francis Gustina, MD, from that hospitalization copy attached. Wherefore, deponent, on behalf of petitioner, requests an order of this court, A, directing Erie County and its Erie County Medical Center to provide petitioner's counsel with copies of all records of petitioner's care at its facility, including records of all care in consultation by Dr. Smith, and to certify to petitioner that records of all care he received at such facility have been provided to him, and B, in the event that Erie County and Erie County Medical Center claim to not possess records of all care provided petitioner at such facility, directing Erie County and its Erie County Medical Center to provide petitioner with a sworn statement as to the creation of such records and how they came to leave its possession, and D, otherwise directing Erie County and its Erie County Medical Center to comply with the order of Justice Gassel granted December 21st, 1984, unquote. Attached hereto as Exhibit I are two copies of Mr. Miller's Esquire signed letter of September 25th, 1985 that provided plaintiff with Mr. Miller's Esquire, quote, motion papers in support of further directives requiring Erie County's compliance with the outstanding discovery order, unquote. Mr. Miller's Esquire notice of motion dated September 25th, 1985 was signed affidavit sworn to on September 25th, 1985 in support of the notice of motion to compel compliance with prior order for discovery dated September 25th, 1985 with attached discharge summary of Francis Gustina, MD, where it is stated, quote, was on consultation to neurologic department and Dr. Smith, unquote. Quoted from discharge summary of Francis Gustina, MD, from that hospitalization as cited above. Mr. Roger J. Wittig, Esquire, Assistant Erie County Attorney, attempts to avoid the consultation by Dr. Smith with plaintiff in his affidavit sworn to on October 25th, 1985, wherein Mr. Wittig, Esquire, states as quoted therefrom at paragraphs 5, 6, and 7 That upon information and belief, the petitioner's attorneys apparently of the erroneous belief that there is a consultation report of Dr. Smith not included in the hospital records. That upon information and belief, it may be that the report of consultation contained in the hospital record conducted by the neurology service during the petitioner's admission on March 3, 1968, was in part a result of a possible conversation between Dr. Tutton and Dr. Smith. That upon information and belief, based upon conversations with the neurology department of the Erie County Medical Center, and in particular, the department secretary, Darlene Kobulski, and also Mrs. Ann H. Pinn, the hospital medical records administrator, there is no separate consultation report on file in the records maintained by the hospital concerning Dr. Smith. Unquote. See Mr. Wittig Esquire's affidavit of October 25th, 1985, attached hereto as Exhibit O. Plaintiff related his great concern regarding ECMC's failure to account for plaintiff's record of injection by Dr. Smith to Dr. Elspeth McPherson, clinical geneticist from Children's Hospital. Plaintiff met with Dr. McPherson in the genetics clinic on June 4, 1984. Dr. McPherson, by her letter of June 7, 1984, wrote to plaintiff regarding our meeting as quoted below. Quote, "You expressed some concern that you were treated at Erie County Medical Center when you were a minor with some sort of drug regimen, and you are concerned that this exposure may have damaged your genes and caused FSHMD in your son. You also indicate that you feel that the research was done secretly by a government agency and that the information may not be contained in the records. Per your request, we plan to obtain records from ECMC and review these to determine if you received any drugs that cause mutations. It is important to keep in mind, however, that we may review records and find no drugs listed which are known to be mutagenic. If this is the case and you still feel that you were secretly treated with some agents, it would be up to your lawyer to follow through on this." Dr. McPherson, upon obtaining plaintiff's records from the March 3, 1968 to March 7, 1968 admission to ECMC, followed up by her letter of August 6, 1984, stating, as quoted therefrom, quote, "I have finally obtained the records of your admission to ECMC in March 1968. There is no mention of participation in research. None of these medications recorded in plaintiff's medical records would be expected to cause gene mutations or any type of reproductive difficulty. If you still believe the records are incomplete, I can only suggest that you have your lawyer contact ECMC directly. Attached hereto as Exhibit P are copies of the original letters by Dr. McPherson dated June 7th, 1984 and August 6th, 1984, described above."